Did you find your jacket?
I did. Yeah, I left it at William Warren's office.
Oh.
I knew I had it, but I don't know, it's going crazy.
So checking communications, we have communications there in Las Vegas?
Yes, we can hear you, Governor.
Okay. We're going to get started here in just 1 minute. All right, if everybody's ready, we'll get started. For the special State of Nevada Board of Examiners meeting scheduled for today, May 29th, 2025, time being 1 p.m. And we will start with the roll call. Ms. Grenemeyer.
Governor Lombardo,
Here?
Attorney General Ford,
Here.
Secretary Aguilar.
Here.
Let the record reflect we have a quorum.
All right, we'll move on to agenda item number 2, the first opportunity for public comment. The first public comment period is limited to comments on items on the agenda. No action may be taken upon a matter raised unless under this public comment period, unless the matter itself has been specifically included on the agenda as an action item. Comments will be limited to 3 minutes. If you wish to call in to participate in public comment, that number being 775-321-6111. And is there any, oh, here it is. The ID number for a call-in is 557-435-475#. Do we have any public comment there in Las Vegas?
No, sir.
Do we have any public comment here in Carson City? Anybody online or on the phone? Seeing none, we will close public comment and move on to agenda item number 3, approval of the new extended or modified collective bargaining agreements for possible action. And Ms. Grenemeyer will take those separately.
Yes, sir. These items were submitted by the Department of Administration, Division of Human Resource Management, pursuant to NRS 288.555, subsection 1, the department, acting on behalf of the Executive Department of the State of Nevada, requests approval of the following new collective bargaining agreements for the 2025-2027 biennium. The combined total estimated fiscal impact of the agreements on the agenda today, calculated by the Governor's Finance Office for the biennium, is $21,277,906. The 2 agreements before you today, combined with the 8 agreements approved at the May 2023-2025 Board of Examiners meeting, has a total estimated fiscal impact of $342,441,658. Starting with item 3A is with the Nevada Police Officer Association for Bargaining Unit M. The estimated fiscal impact of this agreement, if approved, is $122,083. This agreement is presented to a BOE on the understanding that it is effective without signature by the union, as it is a product of signed tentative agreements and binding arbitration. Are there any questions on this?
General Ford.
Thank you so much, Aaron Ford, for the record. So I'm a little concerned that this agreement has not been signed. And I would like some articulation on the record from either counsel in my office or someone who can explain what the ramifications are of us approving an unsigned agreement. I understand what you've just said, Madam Secretary, but could I get a little more legal analysis as to what effect it would be if we were to ratify an unsigned contract?
AG Ford, this is Josh Reed in Las Vegas, Special Counsel for Labor Relations. So the union's counsel is in agreement with the state's position that this agreement, like all the other agreements that were presented at the last meeting, were a result of signed tentative agreements between the union and the executive department and a binding arbitration decision. It is really common. Most unions don't require ratification after a binding arbitration decision. And in discussions with counsel for NPOA, he agreed with me in writing that a signature from Unit M is not required for the CBA to be binding. And I think the policy behind it, most unions would agree with this position because they don't want the state to, not execute an agreement where they won in binding impasse arbitration. So I think most unions would agree with the position that this is a binding agreement resulting from signed tentative agreements and the binding arbitrator decision.
Matt, could you?
Yes, sir.
Well, I appreciate that analysis. It obviously runs counter to what we learned in Contract 101, which says you can't enforce an unsigned contract against the person who did not sign it. But listening to you talk, you're indicating that if you were on the other foot and the state did not sign it, it would nonetheless be enforceable against us as well. Is that your analysis?
The state is a different animal in that and this is in the legislative history of when SB 135, when state collective bargaining came into effect in 2019. The state does require for CBA to be effective the approval of the Board of Examiners. Mm-hmm. And for any fiscal provisions in CBA, it does require appropriation by the Nevada legislature through legislation. So it is a little different. It hasn't been, state bargaining is new. And so that issue of the state, if the BOE didn't approve a collective bargaining agreement that resulted from binding arbitration, the courts have not handled that issue as of yet. But it's definitely it's binding on the executive department of the arbitration decision, meaning we can't go back and renegotiate.
Mr. Reed, can you repeat the last sentence? I didn't hear what you said.
No problem. It is binding on the executive department pursuant to NRS 288, the arbitration decision. And so the executive department couldn't take the position different from what the arbitrator decided, but that doesn't bind the Board of Examiners and it does not bind the Nevada legislature.
Okay.
Yeah, I see that. Aaron Ford for the record. I see that makes a lot of sense. I understand the different entities involved in that particular entity. So issue. So explain to me this though, Josh. What happens if this does not pass today? If we vote against this, what's the effect of that?
So the proposed CBA doesn't become effective till July 1st of this year. And so today isn't, what makes today special is that it's before the end of the Nevada legislative session. The fiscal amount, the 122,000 and change fiscal impact, for those provisions for that fiscal impact to come into effect, the Nevada legislature needs to appropriate the money. for those provisions to become effective. And so by the downside of not approving the agreement would be that the legislature would not be able to appropriate the funds for this agreement because they don't consider the appropriation until after the approval of the Board of Examiners. And so it would be a detriment to the union to not have this passed because nothing guarantees an appropriation from the Nevada legislature, but they wouldn't have the opportunity for that appropriation.
Further follow-up, Governor?
Yes, sir.
I want to be clear on something, though, that you just said about the legislature. I'm not quite sure I agree that the legislature could not nonetheless appropriate funds to accommodate the bargaining unit here and even fulfill the terms of this contract if we did not ratify it. It seems to me that the legislature could, in their pay bill, include salary adjustments in the budget for the governor's consideration at the end of the day that would accomplish the goals of this particular agreement without it having been presented to them from the Board of Examiners. And maybe that's beyond your purview, Josh, but if you have an opinion on that, I'd like to hear it.
I agree. I agree with what you're saying. Nothing binds the legislature. The legislature can, what binds the legislature is they have to do a balanced budget and it has to be approved through legislation signed by the governor. But I agree with you. The legislature can do whatever it wants. The practicality of it based on the legislative hearings on the bills that were passed last week, it appears that they are waiting for BOE approval. The CBAs, the fiscal impacts of the CBAs on the agenda today are not in the bill approving or that are proposed to approve the fiscal impacts of the various CBAs. And appeared based on that committee hearing, they're waiting to hear from the BOE. But it is true, the legislature can do whatever they want. They can give every employee a golden pony, whether it's in the CBA or not.
Okay. Thank you, Josh. I find this to be a very precarious situation. Obviously, it's unique. We've never had to deal with an unsigned contract before. But with the fiscal impact being only $122,000, and with the bargaining unit's counsel acknowledging that their signature isn't required to enforce it because they've been through binding arbitration, and based on our conversation that we just had back and forth, I'm inclined to support, which is different than I walked in here. I wasn't going to support it, but I'm inclined to support the contract based on what you've just said to allow the legislature to at a minimum appropriate the amount of monies that are accounted for here in this particular binding agreement. So thank you so much for the back and forth, Josh. Thanks for the counsel.
I believe we have one more question.
Yeah, Cisco, for the record, my question is, the negotiated dollar amount is agreed to. It's the terms of the contract that the other party has not agreed to sign. Is that correct?
Yes, and part of the reason why they haven't signed the agreement is their counsel has told them it's not required. But the term, they are not contesting the terms in the proposed contract.
Okay.
But any contract that's approved by the BOE, if it requires an appropriation or a legislative change by the legislature, those provisions don't become effective until that appropriation or legislative change is made.
Okay. Is that advice to the client not that it is not necessary for them to sign in writing? And do we have a copy of that guidance? Okay. Thank you.
Was that an affirmative or a negative?
I saw some people nodding their head, but we should get an affirmative.
I apologize. I thought somebody answered for me. We do have in writing that they're from their attorney that he agrees that their signature is not required and the CBA becomes effective with or without their signature.
So let me just ask a quick, does this set a precedent for future negotiation and contract agreements?
Well, I think it's a precedent that most of the unions would agree. The unions don't want the state or the executive department to not submit CBAs for BOE approval because they disagree with an arbitrator's decision. The unions and the state, we both have the ability to challenge an arbitrator's decision in district court under the Uniform Arbitration Act. You have 90 days to do that. It's highly unlikely that that would happen in this case. But, you know, there can be litigation issues that come up after BOE approval. And so what we don't want is our advice is we don't want a precedent of holding up BOE approval because union members disagree with the binding arbitrator's decision. And so I think there is a precedent set, but I think it's a positive precedent for the executive department.
Yes, sir.
Follow up, Josh. I want to be clear, as the Attorney General for the state and the counsel for the executive, I am not sitting on this dais now acquiescing to the notion that an unsigned arbitration agreement on behalf of the executive can be enforced against the executive. You might be right, but I don't want it to be construed as the Attorney General sitting here as counsel for the executive acknowledging and acquiescing to that particular fact. It would take some additional research and or litigation to accomplish that. But back to the original point, which is their counsel has given you written confirmation that they believe that this can be enforced against them, even though it's not been signed. And that to me is a distinction that makes a big difference. I do think, however, there was some confusion relative to the Secretary's question to you. I don't think that the bargaining unit agrees to the number amount. They may agree with the terms, but they don't agree with the number. That's the biggest problem, right? They want this number to be a lot larger relative to what they were bargaining for. Am I right about that?
Yes, I mean, their proposal to the arbitrator would have been a much larger number. And yes.
So aside from the number, the other terms they probably are less concerned about. They are really at odds with the fact that they're only getting $122,000 collective bargaining agreement submitted to the legislature.
Yes, it's 122,000, but also just as a reminder there is also a provision that if all state employees are provided additional compensation, that they also get the same additional compensation.
That makes a lot of sense. Okay, thanks so much. Thanks for indulging me, Governor.
Now I have a question, a clarifying question. Cisco, for the record. So they're not signing the collective bargaining agreement because they do not agree to the amount. But we went to an arbitrator. The arbitrator ruled in the favor of the state with this number, and this is what the number is. They have failed to file an appeal on that arbitration? Oh, the time hasn't run. Okay.
The time that they have 90 days from the date of the decision which was about 3 weeks ago.
So then if we approve this, it gets sent over to the legislature adopts this in its budgeting process. The arbitrator then rules in favor of the union, and there is a different district court. A judge. Then does the legislature have to go back into special session to be able to appropriate that additional funding, or where do we end up?
This has been litigated. There's been litigation in 2021 and 2023 after collective bargaining by various unions. And this issue has been litigated. It has happened where union received a positive arbitrator's decision with an award for a COLA, but it was after the legislature had concluded. It can't be, these appropriations have to be in regular session and not special session. And courts have upheld the notion that if the legislature doesn't appropriate it, they don't get it. And depending on what the legislature does, there could be similar litigation again. But with respect to the amount, I have not heard or received any comments with respect to the proposed CBA that it doesn't include. They haven't contested any of the specific terms of the proposed CPA. The articles that they submitted for arbitration, they wanted them to win in arbitration, and so they have concerns about that. But there have been no concerns about an incorrect fiscal impact, at least concerns given to me through their attorney, or that any of the other terms and conditions are incorrect.
All right, if there are no further questions, I'll entertain a motion for approval.
Motion to approve. Cisco.
We have a motion. All those in favor signify by saying aye.
Aye.
Aye. Motion passes. We will move on to agenda item 3B. Ms. Grinnemeyer.
Item 3B is with the Fraternal Order of Police, Nevada CO, Lodge 21 for bargaining unit N. The estimated fiscal impact of this agreement, if approved, is $21,155,823. Are there any questions on this item?
Do we have any questions? If there are no questions, I'll entertain a motion for approval.
Motion. Go ahead.
Move for approval?
That was the Attorney General that made the motion. All those in favor signify by saying aye.
Aye.
All those against signify by saying nay. I will vote nay as the governor, and motion passes. So we will move on to agenda item number 4, the second opportunity for public comment. This public comment period is for any matter that is within the jurisdiction of the public body. Please limit your comments to 3 minutes. Do we have any comment there in Las Vegas?
No, sir.
Do we have any here in Carson City? On the phone or online? Nope. All right, I'll entertain a motion for adjournment.
So moved.
Yeah, you guys are excited about that one.